Do all beneficiaries get a copy of the trust? Once you're positioned as a beneficiary of an irrevocable trust, which simply means after your loved one passes and their trust becomes irrevocable, for example, vests, you have the right to receive a copy of the trust documents. The trust document operates like a contract and is going to spell out your rights and the trustee's obligations as supplemented by their duties at law. To become a vested beneficiary, you must have a right to receive some benefit under the terms of the trust, whether currently or at some point in the future. As in the case of a presumptive or contingent beneficiary who may become entitled to some benefits at some later date after some condition is met, but doesn't have a current interest in the trust. In the case of a revocable living trust, which is commonly used for estate planning purposes, beneficiaries become vested beneficiaries only upon the grantor's death. This way, the grantor can amend or revoke the trust at any time before death at their whim. For a revocable living trust, the beneficiaries are all contingent upon the death of the grantor and lack the right to see the trust until the grantor passes. Once that occurs, the successor trustee takes control of the trust and its property. The successor trustee must then provide a copy of the terms of the trust to all of the beneficiaries. Have questions? Schedule a free consultation at our website, rmolawyers.com. Are beneficiaries entitled to a copy of the estate accounts? As equitable owners of the trust assets and accounts, beneficiaries are entitled to an accounting from the trustee. A good, responsive trustee is going to respond to that accounting request and give you the information you need so that you have transparency. The trustee is going to need to understand the extent of the trust assets and ensure that they have access to the accounts. Once they have that information, they should share it with the beneficiaries. If they're going to provide an accounting, that accounting should contain at least the following information. 1, the assets that belong to the trust. 2, any income that's been received. 3, a description of any trust expenditures. 4, a list of unpaid debts or creditor claims against the trust, like a mortgage on a house, for example. And 5, an outline of how the trustee plans to distribute the trust assets. Many revocable living trusts will include explicit instructions about how the trustee is going to account. But even if there aren't instructions in the document, the trustees still have a duty to account under the law. After an initial estate accounting, the trustee also should keep beneficiaries informed periodically. While it's usually the case that a trustee is going to distribute the assets from a revocable living trust shortly, relatively shortly, usually within a year after a decedent's death, some assets make that impossible, or at least more difficult. If an administration tends to take longer than the beneficiaries want, then additional accounting should be provided so that everybody has transparency into what's happening with the trust. Can a beneficiary ask to see a bank statement? Sure, beneficiaries can always ask to see more information. And if a trustee is doing their job right, they're really not going to have a problem sharing that information, depending on the facts and circumstances underlying the request, by whom and for what reason. Of course, beneficiaries need to understand that the more information that they ask for and the more work they require the trustee and perhaps the trustee's lawyer to do is more money that it's going to cost the trust, because the trustee and the trustee's attorney are going to be charging the trust for all of that work. So you want to balance it. As an interested party, as a beneficiary, you also have the right to compel an estate accounting from a trustee who's not providing one voluntarily. If you believe that a trustee is withholding information from you and the other beneficiaries, you have options. First, you should always consider speaking with an experienced trust litigation attorney about what's happening and whether your requests deserve a response. Whether you're an interested party or not will be determined by whether you're an heir, a beneficiary, a creditor, or someone else interested or has a claim to the trust property. Anybody falling in those categories can usually request that the trustee provide information. In some cases, an estate accounting can be compelled through court action by any of those people, depending on the facts and circumstances. Whatever the case, an experienced trust litigation attorney is going to be able to advise you on how to compel an estate accounting if you haven't gotten one, or what holes may exist in that accounting if you do have one. They can also help you prepare a lawsuit to remove a trustee, suspend a trustee, compel a further accounting, obtain a surcharge, or seek damages if that's what's required. Have questions? At RMO, we protect people like you every day. Give us a call, shoot us an email, or schedule a free consultation at our website, rmolawyers.com. Thanks for watching.